Yes, good evening to everybody. Welcome to their class. And the today class is the interpretation statutes, a revision class, which I promise that I would like to deal till your examination ends. So now you tell me that what I posted on the screen so that I could know that you are with me, I am with you. Unmute and read. Yes. Anyone can unmute and read that what I posted on the screen.
Good evening.
Good.
Stand up, sir. Respect people's feeling, even if it does not mean anything to you. It could mean everything to them. Professor Dr. Muhammad Saab Hussain.
Very good, very good. That is the thing which I made it over there. Good evening to students of LB3 biology. Respect people's feelings. Even if it does not mean anything to you, it could mean everything to them. Because if their feelings are respected, it is everything to them, but though not, it is nothing to you. So that is the meaning in one way, in another way, that to give respect and take respect, that's also we can say. Yes, come to the point of these interpretational statutes and the rules of interpretation is concerned, because I told you that I will deal the rules of interpretation, and it is because I posted all to you in the group WhatsApp the total 10 questions. So this is one among them. This is a unit 2. Rather, I could specifically say that unit 2. Yes, I will show you that also, this thing. Yeah, this is unit 2. Question number 3. What are the general principles of interpretation? Explain the literally golden and mischief rule with the reported cases. This is the thing which I am going to deal today. And this is one of the question under unit 2 and the question number 3 which I posted to you in today's group WhatsApp. Yes. Then come to the point of this literary rule of statutory interpretation is concerned. The literary rule of statutory interpretation should be the first rule applied by judges under the literary rule. The words of the statutes are given their natural or ordinary meaning and applied without the judge seeking to put a glass on the words or seek to make sense of the statute. So, what are these rules are there? If any words are there, and how it can be resolved, what the idea behind the parliamentarian to use such a word, and what is the meaning of it should be taken into consideration. So these are the rules are framed so that the interpretation given by the courts have a logical ending, and a person who comes to the court should not go with the empty hands also, and the parliamentary intention also can be known, and that's the reason the court will play this role for the interpretation of these statutes. So one of them is the literary rule. So there's some example of the literary rule we'll see with through the case laws, and that is the Fisher versus Bell case law, 1961, Hughes Benz 394. The facts of the case law goes in this way. The defendant shopkeeper displayed in his shop windows a flick knife accompanied by a price ticket displayed just behind it. He was charged with the offering of for sale a flick knife contrary to the section 1 subsection 1 of the Restriction of Offensive Weapons Act 1959. So that is the facts of the case law. Keeping a button chuck, that a flick knife means button chuck, will say. So that is the knife which is kept over there in the window with the price tag in it. But the court felt it. Of course, they filed a case under the section 1, subsection 1 of the Restriction of the Offensive Weapons Act 1959. So the issue here is the issue of whether the display of the knife constituted an offer for sale. So in which case the defendant was guilty, or an invitation to treat, in which case he was not. So there is an offer of sale for sale or invitation to treat. These are the two questions to be resolved by the court. So held that the court, according with the general principle of contract law, the display of the knife was not an offer of the sale, but merely an invitation to treat. And as such, the defendant had not offered the knife for the sale within the meaning of Section 1, subsection 1 of the Restriction of Offensive Weapons Act 1959. Although it was acknowledged that in an ordinary language, a layman might consider the knife is to be offered for sale, in legal terms, in its position in the windows was in inviting customer to offer to buy it. So it's the window shopping, like that window, it is kept over there. It is nothing but the invitation to treat. That is the meaning that you have taken. The statute must be construed in accordance with the legal meaning, as any statute must be looked at the light of the general law of the country, or the for parliament must be taken to know the general rule. So that is the well established in contract law that the display of an item in a shop window is an invitation to potential customers to treat. The defendant was therefore not guilty of the offense with which he had been charged, that he was charged with the Section 1, subsection 1 of the Restriction of the Offensive Weapons Act in 1959. So the court held that the accused is convicted or acquitted. Anyone? Yes, tell me. The accused was convicted or acquitted in this case law? Yes? Unmute and give me the answer.
Sir, acquitted, sir.
It is acquitted because it is not an offer for the sale. It is only the invitation to treat. So that is the meaning which is taken the literal rule. That's why the accused is acquitted. That is the Fisher versus Bell case law. Then another case law, we will see that R versus Harris case law. And what the meaning will be taken here. The defendant bit off his victim's nose. So the statute made it an offense to cut, cut, or wound. The court held that under the literal rule, the act of the biting did not come within the meaning of stab or cut or wound, as these words implied an instrument had to be used for cut, for stab, or wound. Therefore, the defendant's conviction was quashed. So this is R versus Harris case law. They say he was charged with the offense of the biting the nose, but under the offense they made it as a stab, cut, or wound. That is the meaning which he has taken over there. But biting, it will not come under the definition of the stab or cut or wound. Hence, here the literally meaning would be taken, and that is the reason the accused was also conviction was quashed here. Means he was acquitted because the literally meaning is taken into consideration. Because mouth biting is not amount to cut or wound. So because cut and wound, there would be certain instrument would be there, but here the instrument is only the mouth, I mean to the teeth. So it will not be attract the definition of the cut or wound. That's why the conviction was quashed in this case law. Then the Whiteley versus Chapel, this is another case law. A statute made it an offense to impersonate any person entitled to vote. The defendant used the vote of the dead man. The statute related to the voting right required a person to be living in order to be entitled to vote. Hell, the rule was applied and the defendant was thus acquitted. So impersonification, that means dead person. A dead person's vote cannot be casted over there. If anybody was file a case against that person, then the literally will be taken into consideration. Then it will be the acquittal only because dead person cannot vote. That is the meaning of it. So another case law, there is a Ramavatar versus Assistant Sales Tax Officer AR 1961, Supreme Court 1325. The question of the Supreme Court that the expression beetle leaves అంటే ఏంటిదండి? Yes? Anyone on unmute? Yes? Tamalapakulu. Thank you very much. So, whether the sale of the BT leaves could not be taxed because these are the vegetables which are not subject to the sale tax. So they say if the BT leaf is not the greenery vegetables like that one, so hence it is not a commercial crop, it is a vegetable. Hence vegetables should not be taxed under the Sales Tax Act. It is held that the BT leaves has been used by the legislature in its ordinary sense, therefore can't mean vegetable. That means BT leaf we cannot say come under the category of the vegetable. It is a commercial crops and it should be taxed. So that meaning is taken here. It should be taxed or not taxed. Yes.
Should be taxed, sir.
Why?
It is a commercial leaf, sir.
It is a commercial leaf, it is not a vegetable. That is the meaning. Then the Motipur Company Private Limited versus State of BR AR 1962 Supreme Court 660. Let you see that what the case law says. The question was whether the sugar cane fell within the term green vegetables in the entry 6 of the schedule, and such no sales tax could be levied under the Bihar Sales Tax Act 1947 on its sale. So now the sugar cane, whether comes under the vegetable or not, the Supreme Court held that while the dealing with the taxing statutes, natural and ordinary meaning of the word which should be the correct meaning. In the present instance, the word vegetable should be interpreted in its natural and popular sense, that the dictionary meaning is not of such a help here. Vegetable, as the normal people mean by it, are those which can be grown in a kitchen yard, kitchen garden, or kitchen backyards, to be used for the table, that to say to be eaten during the lunch or dinner. But sugarcane definitely does not fall under the category. Hence, sugarcane can be taxed.
Commercial one, sir.
Commercial one, it should be taxed. So that is the case law which is near. And another case law is Mardana Mosque Board of the Trustees versus Muhammad. This case law 1967. The appellate court 13 interpretation of the words is being administered was involved. That is the word which can be need the interpretation is being administered. Under the provision of the act, a minister could pass a certain order. He was satisfied that the school is being administered in violation of the provisions of the act. Applying the literal rule, it was held that the provisions were in present tense, and therefore only present conduct of the school would be looked into it and not the past conduct. So is being administered is said to be the past one, but the past one should be not be considered. The case law says the only present one should be considered. So that is the another case law where we can say that the literary rule is used. So let us see the any other case law would be there applicable in the literal or grammatical rule also we can say. Literal rule can be known as a grammatical rule also. So now it is the first rule of the interpretation. According to this rule, the word used in this text are to be given a or interpreted in the natural or ordinary meaning. After the interpretation, if the meaning is completely clear and unambiguous, then the effect shall be given to a provision of the statute regardless of what may be the consequences. The basic rule is that whatever the intention legislature had while making any provisions, it has been expressed through the words and thus are to be interpreted according to the rules of grammar. So, according to this rule, the only duty of the court is to give effect to the language of the statute is a plain, has no business to look into the consequences which might arise. The only obligation of the court is to expound the law as it is, and if any harsh consequences are arisen, then the remedy for it shall be sought and looked by the legislatures. Yes, that's one of the case law that we can see that Maqbul Hussain versus State of Bombay. Yes, in the case, the appellant citizen of the India, after arriving at the airport, did not declare that he was carrying the gold with him. During his search was carried on, gold was found in his possession and it was against the notification of the government and was confiscated under the section 167 subsection 8 of the Sea Customs Act. So he was penalized over there, and he was supposed to pay the some tax. But later on, that he was filed a suit against him against the Foreign Exchange Rules Act. That is, later on he was charged under Section 8 of the Foreign Exchange Regulation Act, that is called FERA. And the appellant challenged this trial to be violation of the Article 20 sub Article 2 of the Indian Constitution. According to this article, no person shall be punished or prosecuted more than once for the same offense. This is considered as a double jeopardy. It is held by the court that the Sikh Act neither a court nor a judicial tribunal. Thus, according to it was prosecuted earlier, hence the trial was held to be the valid. అంటే అర్థం ఏంటిదండి ఇక్కడ మక్బూల్ హుసేన్ was supposed to be a case would be filed against the Foreign Exchange Regulation Act or not?
Yes, sir. Act.
Yes, it is not a Jabul Jeopardy. Jabul Jeopardy, at that time you will say that when he was prosecuted, the second time he will not be prosecuted for the same offense. But the sea customs is not the prosecution nor the tribunal. Hence, it is doesn't attract the provision of the Article 20 sub Article 2, that is a double jeopardy. So the literally meaning is taken into consideration in that case law. So another case law is Manmohan Das versus Bishan Das, AR 1967, Supreme Court 643. So this is the case law, what it says. The issue is in the case was regarding the interpretation section, that is section 3(1)(c) of the UP Control and Rent and Eviction Act 1947. In this case, a tenant was liable for the evidence if he has been addition and alternate in the building without a proper authority and unauthorized perception as materially altered the accommodation or the likely to diminish its value. The appellant stated that only the constitution can be covered which diminishes the value of the property, and the word or should be read as land. It was held that as per the rule of the literal interpretation, the word or should be given the meaning that a prudent man understand the word of the relevant event or alternative and not combined. So here the question is where the or, how it can be taken into consideration. Whether the building or land, the land spelling, the meaning should be taken instead of the or. So that will be considered literally in that case law, and hence it is literary interpretation is taken into consideration. So now the another case lies state of Kerala versus Mathai, Varghese and others, 1987 AR 33 Supreme Court reporters, and that is 317. In this case, a person was caught along with the counterfeit currency dollar. The currency is dollar counterfeit, and he was charged under the section 120B, 498A, 498C, capital C, and 420 read with the section 511 and 34 of the Indian Penal Code for possessing the counterfeit currency. The accused contended before the court that the charge under the section 498 capital A and 498 capital B of the Indian Penal Code can only be levied in the case of the counterfeiting Indian currency notes and not in the case of the counterfeiting foreign currency notes. The court held that the word currency notes or banknotes cannot be prefixed. The person has held liable to be charge sheeted. When you say the currency is the currency, whether the Indian currency or the foreign currency, doesn't make any difference. Are you following me? Yes.
Yes, sir.
Suppose if they say male should not be, a female should not be arrested. A female should not be arrested in the night with a male constable. అంటే అర్థం ఇది ఇండియన్ ఫీమేలా ఫారిన్ ఫీమేలా? ఎస్. అరే ఇండియన్ ఫీమేల్ అయితే వేరు ఉంటుంది, ఫారిన్ ఫీమేల్ అయితే వేరు ఉంటుందా అండి? అన్లెస్ దర్ ఇస్
ఏముండదు సార్, అంత సేమే ఉంటది.
అన్లెస్ ఇట్ ఇస్ ఎ సిటిజన్ అని చెప్పినప్పుడు వేరైతుంది. ఇక్కడ
సిటిజన్ ఆఫ్ ఇండియా.
సిటిజన్ అన్నప్పుడు వేరైతుంది, ఎందుకంటే ఫారిన్ ఈజ్ నాట్ ఏ సిటిజన్, ఈజ్ ఓన్లీ ఏ విజిటర్.
విజిటర్.
అందుకోసం ఇక్కడ కరెన్సీ అన్నాడు కానీ అది డాలర్స్ అన్నాడా, మరి అది ర్యాండ్ అన్నాడా, ఏమన్నాడు? ఇదన్ను కరెన్సీ ఇస్ ఏ కరెన్సీ, ఐదర్ ద ఇండియన్ కరెన్సీ ఆర్ ద ఫారెన్ కరెన్సీ. హెన్స్ ద లిటరల్ మీనింగ్ ఈజ్ టేకెన్ ఇంటు consideration the state of Kerala versus Mathai, Varghese and others. So literary rule is applied over here. That is about the literary rule, and we have dealt at least 5 to 6 cases in this regard. At least you could remember at least 3 are cases that will be enough for the examination point of view. Next is the Mischief's rule. Of course, we will study the golden rule because after that we can read the Mischief's rule. So the golden rule we will study first. The golden rule of statutory interpretation, how it could works. The golden rule of statutory interpretation will be applied when an application of the literal rule would lead to an absurdity. Suppose if you take the literal rule meaning, then it will lead to the absurdity. At that instance, we have to take the golden rule. The count may be then applied to the secondary meaning. What is the secondary meaning? We have to take it. River where Commissioner versus Adamson. In this case, it is clearly meant the second meaning should be taken into consideration. Like I say the plant. If I say the plant in the biology, yes, creepers we can take into consideration. And bushes, something like that. When you say that in the manufacturing unit or in the industrial state, I say plant, that means the biological plant we should not be taken into consideration, but we should take into consideration what? When you say plant, PLENT.
Industrial.
It is a place where the manufacturing goods will be done, or in another says industrial area where machinery is established over there. That is the meaning we have to take in. So R versus Ellen, this is the case law where the defendant was charged with the offense of the bigamy under the section 57 of the Offences Against the Person Act 1861. The statute states, whosoever being married shall marry any other person during the lifetime of the former husband or wife is guilty for an offense. Under the literal interpretation of this section, the offense would be impossible to commit since civil law will not recognize the second marriage. Any attempt to marry in such circumstances would not be recognized as a valid marriage. అయితే బైగమి అనేది ఎప్పుడైతుంది? ఇఫ్ ఎనీ అదర్ స్పౌజ్ living and the another spouse will got married over there, then the person has committed the offense of bigamy. కానీ బైగమి అయినప్పుడు సెకండ్ మ్యారేజ్ చేసుకున్నప్పుడు ఫస్ట్ మ్యారేజ్ అది ఇల్లీగల్ గా అయిపోతే అది బైగమి ఎట్లయితుంది? కాబట్టి లిటరరీ రూల్ ఇఫ్ యూ కుడ్ యూజ్ ఇట్, then it leads to absurd meaning. Hence, we have to deviate it and take the another meaning of the literary rule. When you say the bigamy, when the person living would be there at the time when he got married the second time, then he has committed the offense. Here, the bigamy means the ceremony of the marriage is taken into consideration. So that is the same thing which is happened over here. The statute said whoever are being made and held that the court applied the golden rule and held that the word marry should be interpreted as go to through the marriage ceremony. Marry in the means we have to go through the marriage ceremony. The defendant was upheld. Conviction was upheld. That means he was booked under the bigamy. So bigamy he was convicted because yes. Why he was convicted? Tell me. Yes, unmute and give me the answer.
Sir, because he did not divorce his first wife, sir.
Does it said here? It is said when you marry the second time, marriage is a ceremony you conducted it. The ceremony may be taken into consideration. At that instance, it is an offense when the ceremony will be take place second time with another woman when the first wife is living over there. Hence, he was convicted under the bigamy because here the literary meaning is not taken, but a golden rule is applied over there to make a deviation, and hence the golden rule will be applied, but not the literary rule in this case for the bigamy. The marriage is what is the definition we should take? The marriage definition means go through the marriage ceremony. That's the definition. We have to take it out. Then only he will be convicted. So next, let us see the Sigworth case law. A son murdered his mother. She has not made a will. Under the statute setting the law in intestacy, he was her sole issue and stood in to inherit her entire estate. The court applied the golden rule, holding that an application of the literary rule would be lead to a repugnant result. He was then entitled to do nothing. So, suppose the mother is there, father is not there, and no other issues are there, only one son is there. Then who will inherit the property after the death of the mother?
Son.
It is only the son will inherit the property. But what the son he did it to take the property instead of waiting for tomorrow's chicken, he wants to have a today's egg. So he wants to immediately want to get the whole property instead of waiting for the natural death of the mother. What he did, son murdered
His mother.
his mother. Can he entitled to inherit the property from the mother?
No, sir.
If you take the literary rule, actually he is supposed to entitle because he is only the legal heir. But his intention of killing is to get immediately the property, and hence it is against the policy, public policy or morality or many other things. Then he will disinherit when he did such a so, because the intention was to get the property immediately. So when the literary rule would be applied over there, he was entitled to get the property, but they say no, he cannot entitled to get the property because he was killed intentionally. That means he is disinherit, and hence he is not entitled to get the property because the golden rule is used over there, and he was thus entitled to nothing. He is disinherited the property. So that is the meaning which you take in golden rule. Then another case law, the Adler versus George. This is the case law. This is accused bench under the Official Secret Act of 1920. It was an offense to obstruct a member of the armed forces in the vicinity of a prohibited place. The defendant was actually in the prohibited place rather than the vicinity of it at the time of the obstruction. That means the court applied the golden rule. It was absurd for a person to be liable if they were near to the prohibited place and not if they were actually in it. His conviction was therefore upheld. So in the Adams versus George case law, if you say that in the vicinity if you are there, then it is an offense. So vicinity లేదు, అసలు ప్రొహిబిటెడ్ ప్లేస్ లోనే ఉన్నాడు అనుకోండి అతను, కాంట్ వి కన్సిడర్ దట్ హీ ఈస్ దేర్ ఆన్ ద విసినిటీ? ఎస్, చెప్పాలండి. అన్మ్యూట్ అండ్ గివ్ మీ ద రిప్లై. అరే బాబు, నువ్వు పిచ్చుకనే చంపవద్దు అని చెప్పిండ్రు. ఏది ఐదర్ క్యాటపుల్తోని కానీ ఆర్ ఎయిర్ గన్తోని కానీ అది గన్తోని కానీ ఆర్ కెనంతోని కానీ దేనికనే ఒక పిట్టనే కొట్టద్దని చెప్పినప్పుడు మరి ఏనుగును కొడతారా అండి?
No, sir.
అంటే అర్థం విసిరిటీ అంటే దగ్గరలో ఉన్నాడే ఉండదు. అది దగ్గర కాదు, అది ప్రొహిబిటెడ్ ప్లేస్ లోనే ఉన్నాడు అనుకోండి, దాని విసిరిటీ అన్నారా అండి?
Yes.
Prohibited place అంటే already there in the red mark area. Even when he was prosecuted, when he stand in the prohibited area, red mark area vicinity also, when he himself on the vicinity, not vicinity, in the prohibited area itself only there, then definitely will call a trespasser or he will be convicted under the offense. ఎందుకు లిటరీ రూల్ తీసుకున్నాను అనుకోండి, విసినిటీ అంటే దగ్గర అవుతుంది, అది కాదు అసలు లోపట్నే ఉన్నాడు అనుకోండి, దెన్ ఈ కమ్స్ అండర్ ద డెఫినేషన్ అండ్ దట్ ద గోల్డెన్ రూల్ విల్ బి అప్లైడ్. దెన్ ద విసినిటీ it doesn't mean that only near to the place. In the place also where the obstruction is there, is standing over there also, it will attract the provision of this section. So hell, the court applied the golden rule. It would be absurd for a person to be liable if they were near to the prohibited place, but not if they are actually in it. Means in the prohibited place standing over there. His conviction was therefore upheld because the literary meaning is not taken into consideration. Then the golden meaning is taken. Hence, he was held liable. So that is the golden rule where we studied it. Then we'll see that any other case law would be there under the golden rule. We'll scroll down. Yes, the golden rule, again it is given, but let us see that whether the same case law is going or not. A different case law it is. Okay, then we'll see the different case law. That is the Tirath Singh versus Bachietyar Singh. That is the case law AR 1955, Supreme Court 850. In this case law, there was an issue with regard to the issuing of the notice under the section 99 of Representation of the People's Act 1951 with regard to the corrupt practices involved in that election. Suppose a person is involved in the election or a court case is there, can he will be eligible for the contesting the election?
Yes, sir.
No, sir.
Provided he should not be convicted. So because still it is not proved over there. So till not proved there, he will be treated to be he is not guilty.
Yes.
Adi meaning this quarrel. According to this rule, the notice shall be issued to all those persons who are a party to the election petition. At the same time, to those who are not a party to it. The Tirath Singh contended that no such notice was issued to him under the said provision. The notice were only issued to those who were non-parties to the election petition, and this was challenged and to be invalid on the particular ground. The court held that what is the contemplated is giving of the information, and the information, even if it is given twice, remains the same. The party to the petition is already having the notice regarding the petition. Therefore, Section 99 shall be so interpreted by applying the golden rule. The notice is required against non-parties only. So, suppose if the notice is given, it means it is to the parties, to the non-parties. Everyone, the notice should be given over there. At that instance, particular notice is not needed because the implied notice would be there. Then one should have to be free from any other charges. So that was the case law. The literary meaning is not taken, only golden meaning is taken, and hence it is applied over there. Thus, again, and another case law, the state of Madhya Pradesh versus Azad Bharat Financial Corporation AR 1967, Supreme Court 276. Issue of the case as follows. Yes, I repeat, issues of the case are as follows. A transporting company was carrying a parcel of apples, was challenged and charge sheeted. The truck of the transporting company was impounded as the parcel contained the opium along with the apples. At the same time, the invoice shown for the transport consists of the apples only. According to Section 11 of the Opium Act 1878, all the vehicle which transport the contraband articles shall be impounded and articles shall be confiscated. It was confiscated by the transport company that they were unaware of the fact that the opium was loaded along with the apples in the truck. The court held that although the words contained in Section 11 of the said act provided that the vehicle shall be confiscated, but by applying the rule of the interpretation for which the provision is to leading to injustice and inequality, and therefore this interpretation shall be avoided. The words shall be confiscated should be interpreted as may be confiscated. So here may be is taken into consideration instead of shall be there. When the shall means mandatory. Suppose the carrier doesn't know that because they said it is the apple boxes, but between the apples there would be some opium is filled over there. Even the carrier will not know that at the time shall be confiscated cannot be used over there, but it should be interpreted as it may be confiscated. Suppose if he knows that apples are containing the opium also in their boxes. So that is the thing where we can take into consideration. Otherwise, we cannot. Suppose if you did not have a knowledge at all, at that instance, you cannot. Common law principle is there. You are not supposed to charge him or file a case against him for a particular offense because he or she himself he did not know what the things are going on or what is containing in the apple boxes. At that instance, only this thing will be applicable. Let us see the another state of Punjab versus that is Oisar Jatan Begum. Oisar, no, Oisar Jalam, yeah, Jahan Begum actually. Oisar Jahan Begum, year 1963, Supreme Court 1604. A period of the limitation was prescribed under Section 18 of the Land Acquisition Act 1844 that an appeal shall be filed for the announcement of the award within 6 months of the announcement of the compensation. Award was passed in the name of the Khaisar Jahan. It was intimated to her after the period of 6 months about his by her counsel. The appeal was filed beyond the period of 6 months. The appeal was rejected by the lower court. That the court held that it was held by the court that the period of 6 months shall be counted from the time when the Khaisar Jahan had the knowledge, because the interpretation was leading to absurdity. You would say that the period will start from the day when it is declared. So instead of it is declared over there when it is brought to the knowledge of the Khaisar Jahan, from that the limitation period starts. That the meaning, the golden rule is taken into consideration in the Khaisar Jahan, and the knowledge because the interpretation was leading to the absurdity. So they counted it from the knowledge of the Khaisar Jahan. The court may applying the golden rule and allowed the appeal. So that was the thing where we can say the golden rule can be applied. Now the still time we do have is 5:36. Then we can easily complete the another rule that is said to be the Mischief rule of statutory interpretation. Yes, so what is the Mischief rule? We will see it. The Mischief rule of the statutory interpretation is the oldest of the rule. The Mischief rule was established in the Haydn's case law, and that is Risak's peerage. It was held that the Mischief rule should not be applied where there is ambiguity in the statute. Under the Mischief rule, the court's role is to suppress the Mischief Act and aimed at and advance the remedy. So whatever the mischief would be there, that should be suppressed by the court, and the remedy should be advanced over there. So that is the aim of the mischief rule. The example of the mischief rule we can see the Smith versus Sachs case law and Royal College of Nursing case law and Elliott case law and Crockery case law as well as the DPP case law. Let us see the first one, Smith versus Sachs case law, how the mischief rule can be applied. So Smith versus Sachs 1960, that is a weekly law report 830. The defendant were prostitutes who had been charged under the Street Offence Act of 1959, which made it an offence to solicit in a public place. So the prostitutes were standing or soliciting from the private premises, from their windows, from their balconies, from their thresholds, but not from the street or on the street or on the public highway. So held that the court applied the Mischief rule, holding that the activities of the defendant were within the Mischief Act was aimed at, even though under the literal interpretation they would be in a private place. Yes, now the act itself say you are not supposed to solicit the customers by standing on the public place. That is the actually the Secret Offence Act 1959 says. They say public place. So now these prostitutes, yes, I told you already in my earlier classes. What is the another name for the prostitute? Anyone? Unmute and give me the answer.
Adultery woman, sir.
But the only explanation that you are given. Okay, next. Next. I already gave, when I was teaching this case law at the time, I gave the Nanardal Japan meaning. We can say loose women, we can say sex workers, we can say call girl, we can say red light area women, but there is another specific women is there, war అంటారు. WHORE, war ఒకటి. నవ్వు హార్లాట్ అంటాము. HARLOT, హార్లాట్. WHORE and HARLOT, harlot కూడా అంటాము prostitute ని. So only Professor Hussain students know these things. Other people, ఇల్లే, nothing, no. Okay, come to the point. Either you standing on the public way, or standing in your balcony, or standing on your threshold, or standing in the windows. If you solicit the customer, yes, the same definition will come out. The mischief of the public place will be suppressed, and the remedy would be taken out from there. The remedy is make them to book under the fence. So when they say public place, it doesn't mean that they should have stand on the public road then to solicit it. Even they are standing in their own houses, from the balconies, from the windows, from the threshold, still they can be booked under the Street Offence Act 1959, because public place includes, the mischief is suppressed, includes the place where you stand and solicit, because solicit is a very important factor than the place. So that is the meaning which is taken into the case law, and they will be booked under the Street Offence Act of 1959 for soliciting the customers by standing, even though they are balconies or houses or windows. Is it clear?
Okay, sir. Clear, sir.
Very good, very good. Then another case law that we will see, the Royal College of Nursing versus DHSS. That is the case law. So now we'll see what this case law says about it. Yeah, the Royal College of Nursing brought an action challenging the legality of the involvement of the nurses in carrying out the abortion. Can the nurses will carry the abortion?
No, sir.
Okay.
Even though they are so much expert also, they cannot do so. Even a doctor also, they could not do so, provided if they are doing for the abortion for safety of the mother. Number one. Number two, the safety of the fetus, because the fetus doesn't develop the mind or head or any other part in a proper manner. At that time, the doctor only suggests, instead of giving the vegetative state baby, better you make the abortion. And that to be within how much period abortion can be conducted?
5th month. 3 months.
అసలు ఫోర్త్ తలుగుతూనే abortion చేయరు.
3 months. Below 3 months.
Generally within 3 months. సార్ విత్ ఇన్ 3 months ఎట్లా తెలుస్తుంది సార్? తెలుస్తుంది, బాగానే తెలుస్తుంది. When the cycle is suspended, everybody knows it. So now the question comes over there. The offences against the Persons Act 1869 makes it an offence for any person to carry out an abortion. The Abortion Act 1967 provided that it would be absolute defense for a medically registered practitioner, that is a doctor, to carry out the abortion, provided Japan rider between even certain conditions were satisfied. That the advances in the medical science meant surgical operation were largely replaced with the hormonal abortion. It was common for those administered by the nurses. Held it was legal for the nurses to carry out such abortion. The act was aimed at doing away with the backstreet abortion where so medical act was available. Suppose even though the doctor was present over there, generally doctor give the direction and nurses will do the other activity. But when there is a death of the mother and consequences of the fetus, according to that one, abortion is allowed. If not, it is not allowed. So that is the mischief is taken, then mischief is suppressed, then they can do it in the guidance of the registered medical practitioner. So that was the thing which is made out there. Let us see the another case law, and this is the Elliott versus Gray case law, and I will stop it after that one. The defendant car was parked on the road. It was jacked up, and it is battery removed. It was charged with an offence under the Road Traffic Act 1930 of the using an uninsured vehicle on the road. The defendant argued that he was not using it, the car on the road, as clearly it is not drivable. యాక్చువల్లీ దానికి ఇంజనే లేదనుకుందాం కాసేపటికి, అరే బ్యాటరీ లేదనుకుందాం, ఏం లేదనుకున్నా, చాసీ కూడా నిలబడ్డా, ఇట్ ఈస్ డీమ్డ్ దట్ ఇట్ ఇస్ అన్ అబ్స్ట్రక్షన్ ద పబ్లిక్ హైవే, even though it is not used in conditions, because whether it is use it or you don't use it, standing itself it is enough, that is the obstacle and that the hindrance on the public highway. The court applied the Mischief rule here and held that the car was being used. That is the meaning, even though there is no battery, even there is no engine at all on the road, as if it represented a hazard. See, it's representing a hazard, and therefore the insurance would be required. Insurance కూడా ఉండాలా, అది ప్లస్ అక్కడ నిలబడదు because there is no parking zone. And in the event of an accident, if it is, for instance, if it is got repaired over there, at that instant they have to keep the impediments in the front and back and side, or the four lights should be beeping, it should be on. The parking lights, four should be, it is palpitating one. So that would be the nature. And in the daytime is there, you have to keep an obstacle stating that it is breakdown is there. In the night, you have to keep the lantern with a red wrapper over it, so that there should be some danger, so that the people will expect and they will deviate from the truth. The statute was aimed at ensuring the people were compensated when the injury due to the hazards created by others. So here the mischief is taken, even though the car is not used, still it should be insured, and moreover it should not be there on the public highway. So that is also another point, without taking any proper care on it. So another case law, we will see the Crockery versus Carpenter case law. The defendant was riding his bicycle whilst under the influence of the alcohol. సైకిల్ మీద పోతాడండి, ఇన్ఫ్లుయెన్స్ ఆఫ్ తాగిపోతున్నాడు. అయితే యాక్ట్ ఏం చెప్తాదండి, లైసెన్సింగ్ యాక్ట్ ఆఫ్ 1872 సెక్షన్ 12 ఏం చెప్తాంది, ఇట్ ఇస్ అన్ అఫెన్స్ టు బి డ్రంక్ ఇన్ చార్జ్ ఆఫ్ ది క్యారేజ్ ఆన్ ద హైవే. అయితే క్యారేజ్ అంటా అండి ఇక్కడ, వెదర్ సైకిల్ ఇస్ ఏ క్యారేజ్ ఆర్ నాట్ చెప్పాలా.
Yes, sir.
సైకిల్ క్యారేజే సార్.
ఇక్కడ మీనింగ్ ఏంటంటే, సైకిల్ అన్నా కానివ్వండి, ఈవెన్ నడుచుకుంటూ పోవడం కూడా కానివ్వండి, ఏది హైవే మీద తాగి, అఫ్ కోర్స్ క్యారేజ్ ఏం కాదనుకోండి, అఫ్ కోర్స్ నడుచుకుంటా పోతే, కానీ స్టిల్ ద పోలీస్ విల్ క్యాచ్ యూ అండ్ పుట్ ఇట్ ఇన్ ద ప్రిజన్ ఫర్ అట్లీస్ట్ in the police station for a time being, because when you are drunken state you are not supposed to be walking on the street, because when you walk in street you are not walking in a proper way, but you walk in a pendulum way. Are you following me?
Yes, sir.
Yes. Held that the court applied the Mischief rule, holding that the riding a bicycle was within the Mischief Act, and the defendant represented a danger to himself and other road users. అది సైకిల్ మీద పోయినా, రిక్షా మీద పోయినా, అంటే రిక్షా తొక్కుంటా పోయినా, దేని మీద పోయినా, ఆటో is different, because auto driver is not drunken, but he was only the passenger who is sitting in the fully drunken state, but he is not driving the vehicle. So you can, when you drunken fully over there, better not to ride the motorbike or the bicycle, or even on foot you are not supposed to go up. Better you hire a auto, you hire a taxi, you hire whatever your money will allow you to do, and you can go in that way. But still, even though the bicycle is not a carriage, but mischief will be suppressed, and you will be booked under it, and you have committed such an offense. So that is the idea behind it. So now the other case law that we will throw light highly in next class, but tomorrow I am traveling to Hyderabad. I will post you why I am traveling Hyderabad, and tomorrow I am not going to take any class, and please excuse me one, and we will resume it, and in advance that I will inform you from time to time when I am going to take the class, when I am not going to take the class. And with this, I would like to say thanks you for very much for patient listening, and we will see you next day after tomorrow at the same timings. Before I close
Thank
it,
you, sir.
you may, yes, please speak. Speak.
Thank you, sir.
Yeah, so you want to say thank you, okay? Because when I heard the voice, so that's why I told you. When you say speak again, you have to repeat it, sir. I said only thank you. Huh? So that was the idea, because I was in the row, I could not hear your voice because I am saying it, and hence I could not say, because somebody said something. I thought that you are going to ask any other thing. The questions would be there for each question unit. I prepared the 2 questions, so 5 units, 10 questions. Out of 10 in the examination, you are supposed to attempt how many?
3.
Is
3,
it
sir.
3? for 2 hours exams.
Five, sir.
Because there is a short questions also there. So the long questions also there. So depending on total five, I think. Two from the short questions, I believe, or three from the long questions. But anyway, but pattern, but only the one thing is very much clear that it is not like the 3 hours exam. That much clear, I can say. Okay. So
Okay,
let
sir.
me stop it.
Okay,
And
thank you, sir.
yes, meet you next day and after tomorrow, most probably, and tomorrow.